March of this year, I still thought I was going to be able to go on holiday in the usual way in May of this year. And I was poo-pooing any suggestion that I wouldn't be able to. And when you're looking, of course, as you know, at construing contracts and insurance policies, you're looking at what the parties had in mind at the time they entered into the contracts. It's very easy to let the hindsight of this year dominate how we feel about insurance policies and so forth at the beginning of the year, because things have changed. Our mindset has changed over the course of the year. So I thought it might be helpful to put a little bit of context in. And then Richard, as I say, is going to go through the test case. I'm going to talk a little bit about the footnote case, and then we're going to draw it together at the end, hopefully with some participation from you about how you feel this is likely to go in the Supreme Court. I'm very anxious to keep within time because I know that we have to finish by midday today. So it's going to be something we canter through. Stop us if you feel that you would like to discuss any particular point in more depth. We're very happy to do that, and we'll see where we go. So in terms of context, let me just see if I can bring that up. There we go. So the key dates for us to look at really starts, as far as the UK is concerned, in March. In relation to other nations, they knew they had a problem earlier than we did. We knew they had a problem, but we thought it was going to be a localized problem, like in the SARS epidemic. That's the one that we're all comparing COVID to. The previous SARS epidemic in China was a problem in China, but it wasn't really a problem for the UK. COVID looked as if it was going to be something similar back at the back end of last year, beginning of this year. How wrong we were, actually. So on the 5th of March, COVID-19 was made a notifiable disease. On the 11th of March, the WHO declared the virus a pandemic. So we knew at that point that it was a worldwide problem. And then in mid-March, things started to move very quickly thereafter, and they continue to move. And that's something that Richard and I would like to discuss a little bit later in this webinar, how things are continuing to change, and our approach to COVID is continuing to change, our knowledge about it continuing to change. Because at this point in mid-March, it was something the government felt was going to be dealt with by way of a lockdown, a single lockdown, I think. That turned out not to be the case, as we all know. So mid-March, the UK government asked people to stay at home. So they were asking people, but they weren't ordering them to do that. It's something that wasn't mandatory at that point. And that is an important distinction when we're looking at clauses to do with advice and regulation and enforcement. On the 21st of March, the regulations started to kick in. So restaurants, bars and clubs to be closed. And then on the 26th of March, closures extended then to retail outlets. So this is the point where clauses relating to government action taken by local authorities, action taken by national government, those clauses start to kick in at that point in March. On the 1st of June, the framework agreement between the FCA and 8 insurers came into force. So the FCA by this point was aware that there was a problem. And the problem occurred between sort of mid-March and May time, where businesses had been interrupted. They were making claims on their business interruption insurance, and some insurers were paying out, other insurers were not paying out. Some similar clauses, some were being paid out and others weren't. And the FCA concluded, unsurprisingly, that there was a problem as a result of that, and that problem needed to be solved, and it needed to be solved very quickly indeed. And that's why they invoked the CPD Practice Direction 51M, which we'll talk about in a moment. Proceedings issued on the 9th of July, matter heard at the back end of July by Mr. Justice Butcher and Lord Justice Flo. So sitting as a divisional court of the High Court, and quite a well-regarded one, obviously. 15th of September, judgment was handed down in the test case. And that's our lodestar moment, where we realise what the judges are saying about the various different insurance contracts. Permission to appeal was given in relation to a leapfrog appeal, so that means that obviously that they don't have to go to the Court of Appeal in between, and the matter will now be heard in mid-November in the Supreme Court. And we know who the judges are for that, and it's quite an interesting choice of judges. We've got the President, the Vice President, We've got Leggett and Hamlin, which is important for reasons that we'll come to in relation to the Orient Express case. So the actual personnel in Supreme Court who are going to be hearing this appeal hearing are not only a well-regarded court, not only a very experienced court, but also a court who've seen these issues before in these specific circumstances. So quite interesting that. So you can see from the time frame here that between the 1st of June and the back end of November, very, very fast dealing with these issues. And I think the reason for that is quite clear. It's a public policy reason. Businesses are going under while they wait to be paid out on their insurance policies. And the FCA is very anxious to get some framework in place to allow both businesses and insurers to plan, to enable them to reserve in the case of insurers, to enable them to claim in the case of businesses, and try and save as many businesses as possible, whilst also not having a blanket payout for insurers, so to save as many insurers as possible. So that's where they're going with it. Very, very quick canter through the dates there. Some obvious stuff on the next slide. It's obviously the longer this goes on for, and in particular, the longer the uncertainty goes on for, the worse it gets for everybody. So the test case in the public interest, and the FCA would say, well, we're acting as sort of we're on the side of the angels here, bringing a test case as quickly as possible. And I suspect the insurers would say that too, because actually their policies are now under the spotlight, whereas other insurers, not so much. But the test case is, the FCA says, representative of 700 policies across 60 insurers, 370,000 policyholders. I actually suspect it's somewhat more than that. So I suspect they're underplaying it to that extent. And of course, as time goes on and as the situation develops, it involves more and more people because more and more clauses come into play. So we've had the first lockdown, we've come out of it, we're in the second lockdown, but we're also now in a tiering system as well. So there will be some policies which are now coming into play as a result of the tiering system that might not have been triggered by other measures taken by the government. So quite a lot of policyholders involved, huge sums of money involved, and that's partly why the matter's gone to the Supreme Court in the way that it has. So just I hope not too quick, but a bit of revision in terms of context there. So over to Richard in relation to the test case itself and the details of that.
Thank you, Sarah. I mean, in terms of the details of the test case, it is an enormous judgment that actually, despite being, I think, the best part of 160 pages, was actually dealt with a commendable degree of brevity by the two judges, which goes to show the level of the detail and complexity. And so in the time frame permitted, there's only so much detail I'll be able to go into, but I'll do my best. In terms of, broadly speaking, who were the winners, I mean, really, you would say the FCA. Not on everything, and they are appealing certain points, but broadly the FCA won. And from the side of this divide in terms of insurer and policyholder, it was a policyholder victory on key questions such as the extent of the insured peril, the validity of Orient Express, and how you address counterfactuals in business interruption cases. More specifically, in terms of this case, the FCA won, to use that language, on the disease clauses, broadly won on hybrid, but I would say lost as such on the denial of access clauses in terms of, and by win and lose, I mean the either expansive or quite restrictive way that these clauses were interpreted. Now I will move on then, if I may, Sarah, to the next slide. I haven't taken that very quickly. So we see here disease clauses, and you can see the insurers whose policies were being considered in this regard. So these are you see that the 4 stages of these clauses. So you have interruption or interference, so effect on the business, then caused by, not in that language, but that's what the second subparagraph means there. So effect on business caused by a notifiable disease, and then within a certain radius. And that may be a radius that's defined, such as 25 miles, or it may be an ambiguous, non-numerical, non-geographical term such as vicinity. But those are the 4 components that you're looking for with a disease clause. So if you're considering one of your own policies that isn't expressed in identical terms to any of those considered in this case, those are the component parts that you should be looking for. Now on, Sarah, is it okay to go to the next one? Now, what the real debate here was the meaning, what was the insured peril in question? Now, the insurers contended that what these clauses were covering were just the effects of the local incident or incidents of the disease. So you look at, or you ask the business owner, what loss can you prove was caused by the occurrence of COVID within this, say, 25-mile radius? If you can't prove that it was just the local effects, if actually it seems as if the loss to your business was caused by nationwide effects outside of that radius, then the insurers say that's not covered. That is outside the insured peril. But that argument was rejected. The court used what I think I'm right in saying was a hitherto unknown term of composite peril, of being the interruption to the business following the occurrence of the notifiable disease within the defined radius. So it's a lot broader than the insurers were saying. What is of crucial importance with regard to disease, and where the FCA really won, was with regard to causation and proximate cause. So the judges said that the wording such as following is a looser causal relation than proximate cause. It's more than temporal. It's more than just a coincidence in time between this event and the loss, but it's not proximate insofar as you have to prove that the nearest cause was, for example, the incidence of COVID in the radius. So they're saying that it's causally sufficient if the disease would not of itself necessarily have caused the interruption to the business, but it would have had that effect via the reaction of the authorities and or the public. So in that very narrow interpretation, the proximate cause would be the disease. A looser causal effect would be the action of the authorities and the public, but the court said it would all satisfy this causative threshold, so it's quite a low threshold. The court went on to say, very interestingly, I think, that even if it did mean proximate cause, this would be satisfied on the basis that the individual local outbreaks, so that outbreak within the defined radius, formed an indivisible part of the notifiable disease, even across the whole country. So that it is artificial and it's impossible to try and hive off the effect of the local outbreak from the nationwide. So it's this indivisibility finding that I think is particularly important. They went on to say that even if that wasn't right, they would each be effective individual causes, but actually that I think is less significant than this indivisibility point. And they go on, paragraph 107, they say the construction we favour avoids the result that there would be no effective cover if the local occurrence were part of a wider outbreak, and where precisely because of the wider outbreak, it would be difficult or impossible to show that the local occurrence made a difference to the response of the authorities and or public. Now, why that paragraph is so important is because it's that rationale that underlines their decision on Orient Express, because they're saying it's absurd, isn't it, that we would interpret a policy such that the larger the fortuity, so the larger the problem, the lesser the cover, because it would be, upon that strict insurer interpretation, actually, the bigger the problem caused by COVID nationwide, the more difficult it is to show that your local occurrence had any effect, which almost offends common sense. Now, the insured, I should say, in terms of when the policies are triggered with disease clauses, the relevant indemnity period only starts with the first occurrence of a notifiable disease within the specified radius. So that's the moment that quantification of loss begins. So it's relevant not only for quantification, but also inherently for business trend clauses, which we'll come on to. In terms of what...
Richard, can I interrupt you just for a moment about that? In relation to the composite peril,
Mm-hmm.
I'm wondering whether that is did they do that, do you think, as a construction point or as a public policy point? So were they just simply construing the contracts? Because I know that's what they said they were going to do at the beginning of the judgment. Or do you think they're allowing public policy to colour the way that they interpret it? Because there's no, I don't think you can really discern any reference to public policy in the judgment other than that Orient Express type issue. But I'm wondering whether there are public policy undercurrents that remain unsaid. But I'd be quite interested to know what you think about that.
It's a very good question. You're absolutely right in saying it's nowhere, and I think this is intentionally, it's nowhere to be found in the judgment. However, well, number one, how to discern and there are always subjective motivations on judges. What their subjective motivations were, we won't know, unless maybe in 15, 20 years' time they give some kind of extrajudicial lecture or something, but we won't know. But what I think is really interesting about this judgment is that it's not as legal as it may have been. It's not as hyperliteralist as it may have been. There is reference to, for example, principles of contractual interpretation, but broadly speaking, and this is where I actually think its strength lies, they try to approach the interpretation with regard to what would avoid absurd results and what would be just, commercially and pragmatically sensible. That being the case, I think inevitably there must have been some public policy effect, because that is really what the public policy dimension here is. Well, notwithstanding the policies may say this and the legal correct answer may be X, actually the real public policy answer lies in Y. And that is what is sensible. So insofar as they have tried to take a sensible approach here, I think there must have been some public policy effect as such.
Oh, and that actually brings me on to another question. I'm really sorry to interrupt you.
No, please.
Get on in a minute. That brings me to a question we've been asked about whether we think this judgment is a death knell for contra proferendum, for that principle. Because they referenced it at the beginning, right?
Yeah. Contra proferendum, I think it's not so much that it's dead, it's just irrelevant. It's like,
that's even worse.
Kim Kardashian's worst nightmare. It's because I really, really super nerdy, but I've sort of noted all the parts that they've discussed. I mean, I've got about 30 odd notes here, but on contra proferendum at the beginning, and it's from paragraph 62 to about 79. They describe the relevant principles and they come onto this contra proferendum principle, and they really expressly affirm, they say that the position on this principle is correctly summarised by as a recorder in a High Court case of Crowden, where after considering impact funding solutions, which is, along with Rainy Skies, are probably the two Supreme Court authorities on this. But the judge in that case said, to this end, the court should not automatically apply a contra profferendum approach to construction. That said, there may be occasions where there is a genuine ambiguity in the meaning of the provision, and the effect of one of those constructions is to exclude all or most of the insurance cover which was intended to be provided. In that event, the court would be entitled to opt for the narrower construction. And here's the crucial part. This result may be achieved not only by the applicable of the contra profferendum approach, but also the approach of Lord Clark in Rainy Sky, that in the case of ambiguity, the court may opt for the more commercially sensible construction. And in terms of its application in this case, it was in respect of the RSA 3 policy, which was an exclusion.
Yeah.
And I think they're only considering it with regard to exclusions, but on RSA's general exclusion L, they say at the end, finally, under this heading, we should say, while we do not consider it necessary to resort to it, this would be one of the few cases in which it would be appropriate to apply a principle of contra profferendum. So, and then they go on later on, I won't go to it because we'll be here all day, but they go on to say essentially, insofar as there's any use in contra profferendum, it may be of assistance, but we've already resolved it. So they're saying not only is it a very rare case where this principle will help, but even in that rare case, there are preferable methods of interpretation. So that's why I say it's not dead, it's just irrelevant. Because they're not saying, oh, it's wrong. Sorry?
That's the last resort. But if you can't find any other way of interpreting it, you just say, well, whoever it is that's proposing the exclusion or whatever it is, you construe it against that person.
Exactly, yeah. But I think, to be honest, that would happen naturally in the course of a hearing anyway, that if you're trying to, it's going to fall on the person trying to actually prove the validity of the clause, to prove it as such, even based on, the fundamental principle of he who asserts must prove. I think it almost relates to that. In terms of how to run a case with regard to this principle, I would certainly not be hinging my case. I wouldn't be advising on the strength or validity of that principle. I may, as counsel, whack it in at the end, as a 16th argument in the alternative or just by way of general background, but I wouldn't place any reliance on this principle anymore.
Okay, sorry, I will let you get on, Richard.
No, it's okay. So I'll move on. So vicinity was, it was considered most, or at least with disease clauses with regard to the RSA 4 policy, where it was defined as an area surrounding or adjacent to an insured location in which events that occur within such area would be reasonably expected to have an impact on an insured or the insured's business. So it's a definition of vicinity that is premised upon its ability to affect the business. So that defines how far vicinity away is just how far it can still have the effect. Now, in this case, the court said that being so, it must be nationwide. Because with something like COVID, even if it happened on the other side of the country, even if it happened in Wales, it still has the ability to affect your business. And as such, it is within your vicinity. The court did recognise that that isn't, common parlance, and it's not an everyday or even necessarily commercial interpretation of the word, but it must be right given the definition in that policy. Quickly, the word manifested means showing symptoms and or having been diagnosed. So if you have somebody who is asymptomatic and undiagnosed, that can't be a manifestation. But then again, I struggle to think how somebody would be trying to allege they had COVID if they had no symptoms or they hadn't been diagnosed, because it would be a gut instinct or something, which is, fairly ridiculous. So Sarah, is it okay, at a time, to move on to the next slide? Thank you. So these are the denial of access clauses. You see the insurers there affected. So these are policies that make no reference to a notifiable disease. Rather, they refer to well, it says here, you have the 4 components, some effects on your ability to access your premises due to really having been told, either as guidance or mandatorily, by a public body due to something like an emergency. But the crucial thing here is that the policy isn't worded with reference to just the occurrence of the disease, it's the fact of not being able to access your property or your premises. Broadly speaking, these were construed far more restrictively than the disease clauses. However, the court emphasised that these clauses were very wording specific, and there was more emphasis with these ones on it being wording specific than with disease clauses. So I think you'd have a better argument on these if you're handling one of your own to say, oh, well, that's all well and good that you may draw some similarities between the wordings considered by the court and this wording, but it's very specific. Whereas with disease clauses, I think insofar as it's broadly comparable, you're probably going to be bound. If this is upheld by the Supreme Court, you'll probably be bound by the similarity. Where these clauses were construed most restrictively was with regard to the width of the cover as such. So they found, almost without exception, that these clauses connoted narrow, localized cover. So it was the action of the relevant authority specifically in response to the localized occurrence of the disease. It's almost the converse of what we saw with disease clauses. Diseases were, everything counts. And then with prevention of access, it is, well, only if you can show that that public body's action was in reference to this local outbreak. So it wouldn't cover the restrictions posed by the government in response to the national pandemic, only the local. So it may be relevant to, for example, the local lockdowns in certain cities. I should say, though, that's everything I've just said is in reference to the wording that we can hopefully see there. So where you have emergency in the vicinity of the premises, or incident within a 1 mile radius of the insured premises, or in the vicinity of the premises, that's where this narrow wording or this narrow construction will bite. There was a lot placed on the distinction between non-mandatory advice and mandatory orders or rules as such. I mean, probably the simplest way of looking at it is that the regulations of the 21st and 26th of March had legal force, and most other things didn't. So, for example, announcements by the government 16th, 20th, 23rd March were advice. So they, insofar as the wording you're looking at requires a mandatory order, they wouldn't trigger that. Now, specific wording for interruption, that doesn't require a complete cessation of business. It includes disruption and interference. Conversely, policies that require prevention, that word prevention of access, must have involved the actual closure of the premises. Now, prevention can depend on the nature of the business. So if the business is able to carry on a part of it which pre-existed March 26th, so for example, if it was a restaurant that had a pre-existing materially sized takeaway service, then their business altogether wouldn't have suffered a prevention, because they could still carry on a part of the business that was fundamentally the same as that business which was insured. That is subject, of course, to where this extra part was de minimis, but that's a question of fact. But it may be, if you can say, listen, yeah, we had a takeaway service, but it was 0.2 of our revenue, then I think you may be able to get around that. However, if the part of the business, for example, the takeaway part of the business is new, and your restaurant had to close, then that would constitute prevention. Notwithstanding that the business was still able to make money, it's because the part of it that could continue, that wasn't prevented, was fundamentally different to the business which was the subject of the policy, which it's attractive in a legal sense, but I'm not sure how much I like it. It's also worth pointing out that the businesses need to have been listed explicitly in the 26th March regulations. So if you're handling these cases, first thing you do is just make sure that your business you're looking at is in that list. So for example, manufacturing, construction, accountants, lawyers, they were all permitted to remain open. Ecclesiastical had an exclusion clause, which the court found was effective, but in a rather academic way said that the better way to interpret it is a clause delineating cover, not as an exclusion clause, but its effect is still there. And this is at paragraph 373.
Sorry, there's a footnote to that. Did they look at the exclusion clause through the eyes of contra proferendum? Not that I'm going on about this at all. Or did they not look at it through those eyes at all? Did they not mention that in relation to the exclusion clause?
Funnily enough, at paragraph 373,
sorry,
quite categorically, they say there is no place for the application of the principle of contra proferendum to the this is really cutting, to the extent that principle has any application in the modern law of construction of contracts. So, you know, as I was saying before, yeah, it doesn't apply here, but it's kind of so irrelevant anyway. Where you have the wording action of an authority, that action must be something with the force of law, really, which means the regulations. Moving on, I'm gonna canter through these because I'm so short for time. Hybrid clauses, I mean, they were just informed by the decisions on disease clauses and denial of access clauses, respectively. So it was a bit of a mixed bag. The only things I will highlight are that the words restrictions imposed require something mandatory. So again, regulations, but not advice or announcements. Inability to use, not necessarily, doesn't have to be complete prevention, but requires something more than impairment of normal use. So there's some difficult wording analysis there. Moving on, Sarah, if I may, to the final, so trends clauses, causation and counterfactuals. Now, the critical issue on causation was the extent of the insured peril. The insurers argue it should be limited to the local occurrence of the disease, and that when you are quantifying the loss, so when you are presenting the counterfactual, and the counterfactual is essentially what the situation would have been other than the, but for the insured peril. The insurers were saying, well, yes, you deal with the local occurrence or you deal with the business being closed down or something like that, but the losses that were caused by COVID generally don't get factored into the loss. And the court rejected that on the basis that the insured peril here is a composite one. So for example, well, it varies depending on whether it's disease or denial of access, but it's a three-stage process. So they say, paragraph 278, the insured peril is a composite one involving three interconnected elements. One, inability to use the insured premises. Two...
Hi, Rich, sorry about that. I just hit the wrong button.
Oh, sorry.
No, Liam was on it instead. I was in the middle of something else. How did it go?
Carry on, Richard.
Oh, shall I carry on? So the second part of the insured peril is due to restrictions imposed by a public authority. And finally, following one of the listed events, which in COVID, with regard to COVID, is the occurrence of an infectious disease. So they say what the insured is covering itself against is, we consider, for fortuity of being in a situation in which all those elements are present. Now, here's the crucial part. In answering the counterfactual question as to what would have been the position of the insured's business, but for the occurrence of the insured peril, it is accordingly necessary to strip out all three interconnected elements, including in this instance, the national outbreak of COVID. So the counterfactual includes the national outbreak, which is really important for quantifying loss. The insurers relied heavily on Orient Express, which really quickly was a hotel that was insured for business interruption caused by damage to the hotel. Now, in that, what happened was there was a hurricane which, caused a lot of damage to the hotel, but also which in and of itself caused some interruption to the business, but also the surrounding area was devastated. So the hotel, in any event, would have been, even if it had somehow stayed physically okay, it would still have had its business interrupted.
This is the New Orleans one, isn't it? The Hurricane
New Orleans, exactly, yeah. In that case, so this is where the makeup of the Supreme Court is relevant, because it was Leggett who was the arbitrator, and then it was Mr. Justice Hamblin, as he then was, who was the High Court judge who upheld the arbitrator's decision. The decision being that the insured peril in that case was just the damage, so that you include into the counterfactual all of the devastation to the surrounding area, which essentially means that their recoverable loss is nothing, which is attractive in a legal and literal sense, but not very attractive in a sort of maybe a common sense approach. The court here with the FCA test case said that they distinguished it on the basis that the insured perils were different, because that case, Orient, wasn't concerned with the composite peril. So they created this new term and then used that as a basis for distinguishing the most helpful authority, which, well, not an authority, most helpful previous case.
I find that convincing, Richard. I don't find that convincing at all, I have to say.
No, it's not. The distinguishing point, I don't think is convincing at all.
No.
Their reasoning on why they say, albeit obiter, why they say Orient was wrongly decided, I think is more forceful, because they say it misidentifies the insured peril in a way that it produces absurd results. And they make the point that the more serious the fortuity, the less cover the policy provides for the consequences of damage to the property. And they say the effect of the insurer's analysis was that the business interruption cover was rendered illusory. And that hurricanes as part of the damage were an integral part of the insured peril, not separate from it. So that right there is a really, really contentious part of this ongoing dispute. And that's, I think, maybe even the main way in which the Supreme Court's decision will be interesting and important.
But doesn't this set us up for a situation where the divisional court, in the form of Butcher and Flo, have been really rude about Orient Express, which was decided by two members of the Supreme Court who will now consider Flo and Butcher's judgment in this? Is that right? Is that the right analysis? If so, that's quite sort of punchy, isn't it?
Well, one would hope that judges of their caliber and seniority wouldn't let ego, which is what that is. Insofar as the word rude has any effect here, it's their legal ego. I think what they could do is not agree and find, oh, it was wrongly decided and what an absurd decision we made, but they could find a roundabout way of achieving the same result. They may distinguish. What they could do is endorse the idea of a composite peril and then distinguish it on the same basis, and then go on to say, but we're not going to resolve this obiter criticism of our wonderful, beautiful judgment. Yeah, but as a matter of plain common sense, the fact that the judges in the Supreme Court are the same ones that decided the case that's been distinguished is relevant. Finally, on business trends, these clauses are those which say, if there was a trend generally which was causing your business to suffer losses up to the start of the indemnity period, you include those business trends as part of the counterfactual that reduces the amount of loss that you can recover. Crucially, what they said with business trends was that they include the effects of COVID on the business up to the point that that specific policy was actually triggered. So if you had a denial of access policy, for example, that was triggered on 26th of March, even if in the month in the lead up to that, you were still suffering, if you were suffering an interruption to your business because of COVID, all of that prior interruption is not recoverable. It's only from the point of your policy being triggered.
So if your business is operating at 80% efficiency at the time the policy triggers, you only get 80%, you only get that degree of efficiency in terms of your loss, right?
Yeah, well, exactly. Well, you look at the 20% and you say that 20% of loss is a business trend, and therefore we include it within the counterfactual, which again, not necessarily the most common sense approach, but I do think legally is right. There. On prevalence, I'm going to rush through this because I don't have time. This is how to prove the prevalence, i.e. the occurrence and spread of COVID in a particular area, and the court placed some analysis on the types of evidence that might be sufficient to discharge that burden. Crucially, the court made no findings of fact on it, but the insurers did make significant concessions about the categories of evidence that may be capable of demonstrating it. So things like NHS death data, ONS data, online reported cases. There are some methods of analysis that they endorse, such as undercounting, so recognising that the official reported figures will, with a sufficient degree of certainty, be lower than the actual number. So this seems like an averaging method as well. And the insurers also didn't suggest that absolute precision is required, which I think was a very reasonable concession for them to make. Now, I will there hand over again, if I may, to Sarah. I apologise for speaking at such length. I tried to cover it as quickly as I could.
Well, yours is the important one. Yours is the 165-page one. Mine's just a little footnote to it. But there has been a case since the FCA case, and it was heard very shortly after the test case was. There is reference to the test case in TKC, but it's very much turns on its own facts, and it's actually an application for summary judgment. So it's an application made by the insurer. It's in here because it's a business interruption one. And it's quite interesting to see how the courts are approaching these. So what have we got? Claimant's cafe had been forced to close as a result of the regulations, and its stock had deteriorated because it couldn't use, it was a creperie, Kensington Creperie Company is TKC. So it hadn't been able to use its stock, so the stock deteriorated. Defendant provided business interruption insurance, interruption or interference with the business caused by an event to property. So it was an event, had to happen to property used by the insured at the premises. So they claimed business interruption, they claimed under the business interruption. They also said an event had occurred to property, i.e. the stock at the premises. The difficulty they had with that, the policyholder, was that event was defined as accidental loss, destruction or damage to the property. And damage, again, accidental loss. So it's all about accidents. And business interruption or property damage caused by or consisting of inherent vice or gradual deterioration was excluded. So you may feel it was ambitious for the policyholder to bring a claim based on the fact that their stock had deteriorated in terms that it couldn't be used. But they did, they brought a claim. They said it was entitled to be indemnified because of the interruption or interference with its business caused by the closure and or the loss or destruction of the stock. It said that because the stock was destroyed, that caused a business interruption. Well, the insurer was having none of it, and Allianz asked for summary judgment on the basis the loss didn't fall within the terms of the policy. It wasn't accidental. The claim was struck out. The enforced closure, so the judge held, did amount to business interruption, but it wasn't caused by an event because it wasn't accidental. Don't forget, event was defined as being accidental within the policy. And it was only a temporary loss, which wasn't enough. A loss, and there's a lot of analysis in this case about loss and whether it has to be temporary or whether it has to be permanent. It's quite interesting on that particular word, on that topic. So I commend it to anyone dealing with a loss case, where it's a loss which may just be a misplacing or something which may or may not be temporary or permanent. So in this case, it wasn't a permanent loss and it wasn't an accident. The secondary case, deterioration in the stock had caused the interruption, didn't succeed either because on the proper analysis, the interruption had caused the deterioration, nor was it accidental. And furthermore, it fell within the exclusion. So it failed on all possible grounds. As a result, the claim was struck out. I think it's quite an interesting one, not only because of the analysis of the case law on loss, which is interesting in itself, but also because I initially thought with these cases that there was going to be a public policy move to try and interpret these clauses in favour of policyholders, and that doesn't seem to be the case. It was so not in favour, in fact, that the claim was struck out. Returning to the test case, so that's TKC just in the middle between the High Court and the Supreme Court hearings. What have we got coming up? Well, we've got the leapfrog bill to the Supreme Court that we've been talking about. Most of the parties are appealing. A couple of insurers and the hospitality group are not appealing their cases. And their main issues is pretty much everything. We've put on the slide, what are the main issues here that are being in contention? Well, the appeal puts everything in contention. But the big one, as far I think as Richard and I are both concerned, is the Orient Express case, because that's something that insurers have been relying on for some time. But the divisional court in the test case is quite sniffy about Orient Express. And they held that although when you enter into an insurance contract, you're taken to be aware of the legal interpretation of clauses that you enter into, that Orient Express didn't really count as being legal backdrop. That's something that you should be aware of, because it was only first instance. It had been subject to some commentary and criticism from commentators, and they were quite sniffy actually about the decision in Orient Express. And that's why I think that's the main battleground here. And it's also something that actually, and I know that Richard will say that ego shouldn't get in the way and doesn't get in the way when you're in the Supreme Court, but I think it's something that is likely to take up quite a lot of time in the Supreme Court, partly because the personalities involved, but also because Orient Express is a really important, I think, principle of construction in relation to these policies. So that's where I see it going. The other grounds of appeal, I think, are more wording specific, but this whole composite peril theory, I think, is the important one here. Just got a question, which I'm going to just have a look at in the chat. What is the view on the second lockdown forming a second trigger? Depends on wording, Richard says. Or is the opinion this still forms part of the original lockdown? I think it's a second trigger, probably. Of course, it depends on the wording in the way that all of these policy documents will do. But I can see there's an argument that the response to COVID as a whole is one continuing event. But I also see the argument that says that these lockdowns are being triggered in different situations. So don't forget, we had lockdown 1, we all came out, then we had the tier system, and then we had lockdown 2. And I think there is a distinction there. It's not a total, it's not a seamless happening. So my own view is that it's probably a second trigger, but yeah, it's going to depend on the wording. Sorry.
I was going to say, most of the legal decisions in this case will be transferable, obviously, to later COVID situations. But I think on timings, I do think it's specific to the factual matrix underlying, let's call it the first lockdown, because a lot of it is done with reference to the regulations of the 21st and 26th of March. So where you have time covers, I think it'd be better to look at it as a second trigger personally, but I think that would be legitimate.
The take home from this is isn't it, a really typical barrister's take home, that you need to, there is no substitute for actually reading the clause. And, you know, whilst we try and provide some kind of, this is how it's going to be interpreted type advice, you've actually got to read the words, I'm afraid. But I think, Lawrence, we're going to have to leave it there. I don't think we can take any questions.
The only thing I would say, though, is that in the meantime, if I were handling these cases with the upcoming Supreme Court hearing, and probably then very soon after judgment, I would not be making personally any decisions on particular policies pending that appeal. So I would be stalling for time. And if necessary, I think if you were compelled by even, for example, directions to plead or to, even if you have a hearing or something like that, I would probably be applying for a stay and saying, giving these completely exceptional circumstances where we're going to have determinative guidance on this question within a month, it's ludicrous for us to run the risk of having a contradictory decision now. So so for all insurers and insurer solicitors here, I'd be saying just play for time.
Okay, that's brilliant. Thank you very, very much, Richard and Sarah. I think that's been really, really helpful. I apologise to everybody who had a question but didn't have an opportunity to ask that question. I'm sure Richard or Sarah will be more than happy to pick up your questions directly. Obviously, they can be contacted at 1 Chancery Lane. Yeah, just thank you very much for everybody who's joined. I hope you all found it useful. There will be a write-up coming out to all registered members of FOIL and FOIL Select. So look forward to seeing that. And thank you once again, Sarah and Richard. Thanks very much.
Everyone. Cheers. Have a nice day.
Thank you.
Very happy to answer questions. Very happy. Thanks, Lawrence. Have a good day.
Yeah, thanks very much, Lawrence. Cheers.
Cheers. Bye. Bye.